all, of course, very welcome to be here. I do want to remind everybody in terms of the expectations of the court when reading the verdict and after the verdict, in terms of people reacting, responding. I don't want to have anybody removed. It's appropriate, of course, for you to sit here and to listen and to observe, but to not do anything more than that. Thank you. Ms. Alford, if you'll get our jury, please. And Mr. Edmondson, if you'll get our alternates. We're going to wait for our alternates. They're on their way. Please be seated. I'm going to turn my attention to the foreperson. I understand, Mr. Foreperson, that you have reached a verdict. Is that correct?
Yes, Your Honor.
Thank you. If you could please hand that to Ms. Alford, our bailiff. Court will now read the verdict forms. Jury verdict count number 1, criminal attempt to commit first-degree murder. We, the jury, find the defendant, Dynel Catrice Lane, guilty of attempt to commit murder in the first degree. We further find, with respect to the verdict questions for this count, as follows. Did Ms. Lane use or possess and threaten the use of a deadly weapon? Yes. Did Ms. Lane cause serious bodily injury or death? Yes. Jury verdict count number 2, assault in the first degree, throat area by means of hands, a knife, or cutting instrument. We, the jury, find the defendant, Dynel Catrice Lane, guilty of count number 2, assault in the first degree. Jury verdict count number 3, assault in the first degree, abdomen area by means of a knife or cutting instrument. We, the jury, find the defendant, Dynel Catrice Lane, guilty of count number 3, assault in the first degree. Jury verdict count number 4, assault in the second degree, head area by means of a bludgeon. We, the jury, find the defendant, Dynel Catrice Lane, guilty of count number 4, assault in the second degree. Jury verdict count number 5, assault in the second degree, throat area by means of hands. We, the jury, find the defendant, Dynel Catrice Lane, guilty of count number 5, assault in the second degree. Jury verdict count number 6, unlawful termination of a pregnancy in the first degree. We, the jury, find the defendant, Dynel Lane, guilty of unlawful termination of a pregnancy in the first degree. Counsel, would anyone like me to poll our jury?
The people do not request a poll.
Yes, Your Honor.
Thank you. I'm just going to start here in the back left, and I'm not going to name you all by name. I'm just going to turn to you and say, is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
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 Thank you. That concludes the polling of the jury. Ladies and gentlemen, I would like to turn first to our alternates who have been sitting locked up in a room, and I extend my apologies to you. I know you understand the reasons for that. I would like to thank you very much for your time, for your attention. Mr. Edmondson is going to take you back to the jury room, and I'm going to ask if you can stay for a few minutes. I'll come back and chat with you in person so I can thank you in person. You are all excused. Thank you. I have one last instruction for all of you. You have now completed your duties as jurors in this case and are discharged with thanks of the court. The question may arise whether you may now discuss this case with the lawyers, defendant, or other persons. For your guidance, I instruct you that whether you talk to anyone is entirely your own decision. It is proper now for others to discuss the case with you, and you may talk with them, but you need not. If you talk with them, you may tell them as much or as little as you like about your deliberations or the facts that influence your decision. If any person persists in discussing the case over your objection, which I doubt would happen, or becomes critical of your service, either before or after any discussion has begun, which again I think is unlikely to occur, please report that immediately to one of our bailiffs or directly to me. I thank you for your time, for your attention, for your hard work, for your participation in this important process. I'm going to have Ms. Alford take you back, and I will ask you to wait a few minutes so I can come back and thank you personally. You are excused. Please be seated. Counsel, with respect to sentencing.
Are you requesting, with regard to setting a sentencing date?
With respect to the scheduling of sentencing.
And first of all, Your Honor, let me also request, now that there's a guilty verdict on behalf of the people, that the defendant be held without bond until sentencing.
Thank you.
The people's position, Your Honor, is there should be a very thorough pre-sentence investigation prepared with a thorough psychological evaluation ordered by the court. And I'd like to have the sentencing date scheduled at a time that's convenient for the Wilkins family to travel and be present.
Thank you, Mr. Garnett. Ms. Harold.
Your Honor, I object to that. We can't object to the PSI itself, but any further evaluation we would object. Although my client was convicted today, she does have a right to appeal, and that allows all her constitutional rights to still be in effect. And I think it would be inappropriate when somebody is looking at mandatory prison and it's just a matter of how long it's going to be that you order that type of evaluation.
Thank you. The court, first off, will grant the motion to modify bond to a no bond. I will set the matter over for sentencing. I will order a PSI. I will allow the parties to have 14 days to brief the issue of psychological testing. I suspect that at the end of the day, even if I were persuaded that I had the authority to order that under these particular circumstances, Ms. Lane could simply decline to participate, and at that point in time, quite frankly, it just becomes a moot point. So the attorneys can decide under those particular circumstances whether they even want to brief the issue. I will, because I have ordered contemporaneous briefings, direct that you meet and confer, so that if the district attorney's office is not going to ask for that after all, defense counsel doesn't have to spend their time preparing to address the issue if it's not going to be requested. I have, in terms of sentencing, I was thinking that if I set this for Friday afternoon in late April, that would give ample time for the PSI to be prepared. I'm thinking either April 15th in the afternoon or April 29th in the afternoon. April 15th might be a little bit too fast for the PSI writer.
Your Honor, I'm not available the 15th, so I would request the 29th.
Your Honor, it looks like actually the 27th is the Friday. Is that what you're looking at?
In April?
Oh, maybe not. I would defer to the court's calendar. Whatever day you have is Friday, I'll agree that's it, Your Honor.
If somebody else wants to tell me I'm reading the calendar wrong, I'm happy to take another look. But what I'm seeing is Friday, April 29th. I'll set you at 2 o'clock, and then I won't set anything else.
Thank you, Your Honor.
Thank you. Anything further, Mr. Garnett?
Nothing for the people. Thank you, Your Honor.
Anything further, Ms. Harold or Ms. Beck?
Hold on, Mr. Garnett.
Of course.
Nothing further at this time, Your Honor. Thank you.
Counsel, I want you to approach briefly, please.